Hi everyone, it's Grant Abbott speaking. Welcome to the launch of the Protector, which essentially is a series of tools and resources and documents, etc., that are designed to protect family assets in the event of litigation during life, and more importantly, family provisions litigation after death. We've got quite a lot to go through, and I just want to give you a couple of heads up here. Is that the Protector is designed to draw out existing equity in properties. I know Tim Munro is a great believer in using them for all his clients for properties. Has in the past been charging $7,500 for that strategy and doing very well. And some of you know Tim from Change GPS up in Brisbane, so shout out to you, Tim. Great for people who have got businesses, all of us who are professionals who are exposed daily to potential litigation. Again, we need to have the Protector on foot. For those of clients who've got really anything that potentially is going to go into an estate, which is going to be subject to a family provisions claim, effectively they should be looking at the Protector. It is, in fact, if you have a look at it for me, it's fairly ubiquitous and it's the best strategy. And I've come out of SMSFs and, I love my strategies there, but to me, this is the best by far. And more importantly, if done correctly, there's no capital gains tax, nor is there stamp duty. So we'll go down that track there. We want to make sure for our clients, safety, security, and certainty. And also it's a great strategy really for all of us here to put in place currently. In fact, I'm going to be doing one for myself today. It's just crazy not to. Anyway, it's quite funny because I had a dream this morning that I caught up with an accountant, couldn't picture the face, but I was at a talk. So sometime in the future, and it was an accountant who was not using LightYear docs, but had been to some of our trainings where I've been talking about the Protector, and in fact, in this one, I was going through the Protector and around estate planning, getting into quite a lot of detail, because I see this as just like the first step in a broader succession and asset protection field that we're all going to be working in. They were being sued for SMSF advice and basically put through the ringers by ASIC. He had his home exposed. Had his whole share portfolio, his whole business was being closed down. ASIC was looking at winding up, and effectively he was being sued under the SIS Act for recovery of losses by a client. Everything was at risk, and he wanted to backdate. And don't laugh, I see this quite a lot, that people are seeking to backdate. You see, for example, in the investment strategies, we can go through and we can do deed of ratification, deed of rectifications to effectively legally backdate as best as possible. But still, you can't really backdate an original document. Particularly something like this, you'll see as we're shifting equity between various structures, and it's important structures that we send them to, that we make sure that it's done in time. Otherwise, it's going to be very easy to come and have an attack. For bankruptcy, obviously, you've got your clawback provisions. So if someone's going to go bankrupt, you can't go and put the Protector in straight away because they'll just claw it back. Family law, you have potentially a bit of success on protection there. Again, you can't really stop the family law court looking through everything these days. So I'll cover at a later stage, it's not for this one, but how the Protector and the Family Law Act work together. The other one is estate planning for family provisions. It works extremely well. The only danger would potentially be New South Wales, where you've also got likely a clawback where you put money into a trust with the intent of minimising the estate. But it goes back 2 or 3 years. So again, it goes to the stage that if we're going to put it in place, we want to put it in place now. And I'm going to cover the issue of what happens if the values go up or the values go down in the equity. Because as our clients get more successful, they get more assets, then we need to increase the Protector. The real protection, though, as I believe, is the comes with estate planning. I'm going to show you the Angela Miller case now. And I think this is fairly demonstrative because what we're doing now is working out, well, I'll take you through exactly what the protector is, but who is the field or the sphere of influence that has an impact on the protector. Because obviously professionals, anyone with properties, etc. Now this one is, you may have seen it before, but I think it's just instructive again. So this is April the 1st, 2018. A Supreme Court judge has launched a scathing attack on lawyers who feasted on a small family estate with their indefensible legal fees, describing it as a scandal that brings the profession into disrepute. Justice Jeremy Courtois' withering takedown was aimed at the lawyers involved in the case of Angela Miller, who was contesting the will of her late de facto partner, Andre Taylor, who left his entire estate worth about $600,000 at the time of the 3-day trial last October to his 2 adult children, Elizabeth and Philippe. In a recent judgment, it was revealed the combined legal costs were potentially more than $500,000. That was at the date. In fact, I've read the transcript of the case. So that was at the date of the hearing, and there were 6. In a case involving 6 lawyers, 1 from interstate, but which should only have had 2 according to the judge. So the lawyers had not yet billed for the costs of this Supreme Court matter. So it would have easily been $530,000, $540,000. The funny thing is, before we got to all of this, Justice Courtois awarded out of the $600,000 Angela Miller, the de facto who'd been left out, a $240,000 out of that $600,000. But in the end, she got nothing because, as I said, the small estate had been ravaged by legal fees, he said. The costs on this matter are not as counsel for the executor described them. Unfortunately, they are a scandal to the administration of justice and bring the legal profession into disrepute in the eyes of the public. Estates are not there to be feasted upon by lawyers, but to go to the beneficiaries and those who might be entitled under the Will, the Administration Act, or the Family Provision Act. No citizen of this community being informed of the costs incurred relevant to the amount of the estate could be anything other than horrified. Family provision matters are generally not complex, and costs of this magnitude relative to the value of the estate are inexcusable. Anyway, so you can go through that. Interestingly, this is not like the first roundabout on this sort of stuff. This goes on, I can tell you, day in, day out in our profession, is that the whole idea about an estate, you can see it's no win, no fee, is like family law, is to create a state of aggression, a state of fighting, where both sides are pitted against each other to a fight to the end. No, I just got off the phone with a good mate of mine, Simon Makem, who again has gone through the ringer on this one for a client for exactly the same sort of situation. And again, it dealt with property and SMSFs. A bit of prior planning and use of the protector, you see, although the whole estate in that on Angela Miller and Andre Taylor case was one property. It was one property that was worth $650,000, which was sold and ended up, the proceeds were held in trust. In solicitor's trust was $600,000 at the time of the case. So it's not as if we're talking about millionaires. We're talking about people who are even small. And that's the hard thing, because the protector that I'm going to show you has generally been charged anywhere between, $7,000 to $10,000 to $15,000 to $20,000 by solicitors out there. There's no super sophistication to it, although from the documentation I've seen, certainly the ones that were created LightYear docs are miles ahead. I'm going to take you why we're different. But importantly, for those of you who are licensees on our system, or what we call our unlimited users, such as LY strategists or LY firms, you can do as many of these as you want. And there's around about 7 or 8 documents which we'll go through. So this is a brand new line of opportunity for your business. Work out the pricing. I would think the minimum pricing is around about $3,500, but it can go anywhere. If you're looking at a $5 or $10 million estate, when I mean an estate, assets which are in people's personal names. And particularly, that's not a big one when you start to have a look at the value of homes around Sydney, Melbourne, and Brisbane, and even, gosh, Sovereign Island. Some of those ones are definitely a need for a protector. The bigger the equity, I'm going to show you what to do about that, the bigger the fee. So this is, to me, look, forget about SMSFs, forget about everything else. This is the absolute bee's knees in strategies for you and your clients. I can't think of many of your clients who effectively would not need this unless most of their assets are residing in a self-managed super fund. But if you've got those assets going over into an SMSF, then you need an SMSF Death Benefits Trust. But that's a different talk, and we'll look at that on the 23rd and 24th of March at our two-day conference. Anyway, the client use of the protector. Basically, it's for any professional. So for myself, all of you listening in, whether you're an accountant or you're a lawyer or you're a risk agent or you're a financial planner or you're an SMSF auditor, essentially, we've got to be in a position of putting this in and protecting all of our assets. As you'll see a little bit later on, the protector is not only for us individually, so it can work not only over assets that we own personally. You can actually throw a protector around a family trust. So a discretionary trust can gift any equity it has to a separate specialist trust, and I'll look at that a little bit later on what you really need to be doing there. And more importantly, by doing that, particularly if that trust is in business. So if you're running your accounting practice or your financial planning practice through, or the doctor's practice through the trust itself, then there's a chance that if something goes wrong, the action will be taken against the trust and also the doctor or the professional jointly. So again, it's good to say, okay, we're going to take our equity out of our individuals, but we can also take it out of our trust and put it into a protection or an asset protection trust. Now, anyone in superannuation, if you're doing super, you need the protector. I can tell you at the moment, it's quite funny again with working with Tim, but effectively we've just written a letter to all the directors personally under the Superannuation Industry Supervision Act, and suing them personally under Section 52A and also 54B. Directors of a registrable entity are personally liable for any loss or damages occasioned by any superannuation member. And we believe, well, we know we've got a strong case, and it's going to be interesting to see how it plays out. But again, all of those directors, anyone to do with it as an individual, anyone touching anything to do with super needs the protector. Builders and subbies, obviously, property developers, that goes without saying. I mean, property developers shouldn't have a cracker in their own name, otherwise it's going to be a disaster. Building and subbies the same. Directors, freelance workers, IT. For those of you, I can tell you, when we built LightYear docs last year, we had a huge problem in around about February. We were supposed to be launching, and our whole system went down. We lost all the work we'd spent 6 months on going through. Our IT people made a big stuff up, but we couldn't recover against them, unfortunately. And because, again, that's always the way that, it's not my fault, and everyone points the bone at the other end, other people. But, that costs us probably around about maybe $200,000 to $300,000, that one stuff up. So that's an IT. When you get into an IT project, sometimes you just put it behind you and you move on, because you can't, it's very hard to change IT people midstream. But if this happens to you, absolutely IT. Doctors, nurses, dentists, healthcare professionals, look, we're all exposed, even small and medium business owners. Something goes wrong. Someone comes to the cafe that we have, and we find that, they end up with some disease or whatever. And you see that in a number of cases, you know, all these 30 people ate at this place and they ended up with streptococcal infections or whatever. So again, we need to have that protection. Property as well, someone comes into your home, falls over, your home and contents might help, but you know what insurance companies are like, they try to weasel out car owners as well. So Tim raises that because he's a man who's a great collector of cars. So, you know, from that side, the really most business and professionals and everyone who potentially can get sued. And that also includes employees as well. So that if your employer can sue you for recovery for doing something wrong, you need to, again, have protection. Now, with the family provisions claims, there was a case that went back. I looked at it a few weeks ago. Went back to 2012. Just forget the name of the case. Will come back to me shortly. But in that case, under the Family Provisions Act in New South Wales, not necessarily in other states, but you can go back. Ex-spouses can claim, and in this instance, they went back to, just to show you, the lawyers who were making the claim against the executor of the estate went back to find the Filipino wife who'd been married to the deceased for a period of 1 year, and that marriage was annulled because she was actually married to another gentleman over in the Philippines. But she still had standing under the Family Provisions Act to make a claim. So really, when we have a look at that, we have a look. Remember the Taylor and the Taylor and the Miller case before. Really, it's quite open slather for family provisions. That's a scary thing, and that's why my goal, particularly with this new succession and assets protection strategies we're doing, and the profession that I believe is coming out of it, is to try and whittle down estates such that ideally, at the end of the day, when the client dies, the estate is worth nothing. So absolutely nothing. Then there can be no fights, there can be no Family Provisions Act challenge, because if there's nothing there, no one's going to fight for it. However, all of that can be put into lineage and bloodline trusts, which have the same impact. And of course, if for those who are running SMSFs, we can put it into an SMSF Death Benefits Trust. So our goal is to keep stuff away from the estate. So we need to protect estates by not having any, as I said. We can transfer all our assets, personal assets, into a trust that provides asset protection for life. But the good thing about this is that where we have this, not only provides asset protection during the life, but also after death, which is important. And we can transfer the equity out of family trusts, out of individuals, and can all go into that one trust, that one asset protection trust. Now, my preference is, as we go down the track, is to use what we call a leading member discretionary trust. Essentially what it is, I'll talk about it a little bit later on, but the main thing is you've got the power with your clients when building one of these to limit control of that trust and distributions of that trust to just lineage, which is defined as being direct descendants, much the same as the Queen, for example. If we have a look at it, Prince Harry is obviously lineage, but his wife, Meghan, whatever her name is, Meghan Merkel, or I don't even know. People getting mixed up with Angela Merkel. I'm sure Harry wouldn't like getting married to Angela Merkel, but anyway, no disrespect to Angela. But then we've got bloodline, which is anyone who's got our DNA. So that can go wide, it can go up and go like second, third, fourth cousins. So bloodline is not too bad, but we've just got to be careful about anyone saying bloodline trust, because they can be they can be potentially challenged. And there's a couple of ideas we need to put in place regarding appointorship, succession, and also trusteeship as well. We can convert an existing trust to one of these if we want to do so. The only problem is that if we have an existing trust, it has all its baggage with it, and particularly if there's a business in there, we actually want to pull the equity out of that trust and put it into something that's clean and it's built for protection. So much of the same as an SMSF was built for superannuation, we're building this specific trust for asset protection, but also passing legacy wealth to lineage. And if no lineage is there, then on to bloodline. I can tell you, your clients will love you for this. So not only are you protecting the assets, but you're also streaming them to future generations. Now, obviously, we've got the 80-year vesting rule in terms of the rule against perpetuities, but we can set these up in South Australia where the rule against perpetuities does not apply. So we can put it in existing trust, but we just watch out. So like anything, what we're doing now, we're building these strategies for you. So this is a done for you strategy. So if we've seen what we've talked about and we started going through your client list, there are so many clients out there who this could potentially apply to. So the first thing is we could either get them in, talk to them, but really I think the whole idea is getting the information out there to the client, letting them book the appointment, and then from there you can then explain the process of the protector to them face to face. And then you can discuss the costing, the upsides, the potential downsides, for example, a bankruptcy, family provisions clawback, potentially a family law look through, but we can cover that, but also the huge upsides in terms of litigation and family provisions. Just simply, if I was going through the client, in fact, there's a client engagement letter, I would probably attach this article here to the client's to an engagement letter. So what we could do is when we go into LightYear Docs, and you can see here I've logged in. If I go here, I'll go back into this. So you can see here, I'm not logged in. So it means there, I've got my home, I've got my product categories, but there's no support center. So the support center is only when you're logged in. And there's no cost if you aren't registered already, you need to be registered. So just set up and you can log in, and it's quite easily. If you haven't done one before, then you simply register as a new login. So what we do there is we simply go up and we're going to look at our support center. Just as an aside while I'm here, this is the LY Strategist, which is essentially $795 a month, which includes unlimited CPD, so on and so forth. Or if you want to take a license, the license fee is $6,950, which is pretty good for a year. That's unlimited documents, unlimited CPD, and technical support from me. So to get technical support, see down on the bottom right-hand button, we've got our support center. So you put your name, your email address, how can you help me, attach files. So if you've got any client queries, you put that up to us. And then what that happens for me is you'll see in our system, the good thing about us, we've actually picked up a lot of people who've either been with Now Infinity or Trustee.com or whatever, who essentially, they don't get any support. We are assiduous and make sure that we attend to all our support tickets, including me. So you can see there, we've had around about 3,000 support tickets, a lot of them technical. So you can see there we've got Paul who's asking about a leading member deed. So I'll be coming back to that. So we had to actually change our leading member documents for that one. But we've only got 2 tickets. So again, technical ones, feel free to come through that. So the best way to do that, rather than send an email which gets lost in my email, nothing gets lost on our support center. So that's the best way. So that's just a bit of a tip. So what I've done is I can see there I've got the support center. You'll see, for those of you who are new to LightYear Docs, there's a really good explanation video down here on LightYear Docs being your complete business partner. But we want to go to the support center. All our videos, again, you can search here, all our videos are here. So this video I'm doing now will be up here early this afternoon. Now, this is the one that is really useful for a lot of you. So Again, as I said before, we can get our client in and talk about asset protection, absolutely importantly. Or alternatively, we could actually do a seminar on it. And I'm more than happy to come and do seminars for our licensees down the track. So here's a letter that we've done. This is the asset protection. You can see that it's downloadable. So it's a Word doc. So you can change it as you see fit. So this is just our suggestion. As I said, it's a sample letter. So the idea is to send this out to your clients. So this has been designed to encourage clients to implement a sophisticated but simple asset protection strategy. Importantly, it's not advice, but a call to action, being an appointment to find out more about how asset protection can help protect their family wealth. So the whole idea is to go through this and get an appointment. The LightYear Doc strategy solution, the protector may protect and quarantine existing equity of value in assets such as homes, investment properties, equity and trust investments, cars, artwork and social media. In fact, I will be re-releasing our will next week. And it's very exciting because I've had a lot of feedback on our will. And so we've got now built into our will, you can do just a basic will if you want. You can do a basic will with an option of a testamentary trust for any asset or bequest that is received by any beneficiary. Or we can do a mandatory testamentary trust put in place, again, for any beneficiary's bequest. And also we've just included social media there, who looks after your social media and who gets the right to any property rights inside your social media, plus also pets, who is going to be looking after your pets when you pass away. So it's like a pet guardianship. We haven't put child guardianship in there because that should really be countenanced quite separately from the will, as, for example, an advanced healthcare directive, which are coming down the track. But look, make sure that you register for next Thursday's LightYear Docs webcast, where we're going to have a look at our brand new will. It's very exciting. Anyway, the quarantining is from litigation, family provisions claim for the benefit of the client's bloodline and lineage decide. Estate planning. Apart from the immediate benefits the protector has during their life for transferring wealth equity from an individual and even if trust warranted to a protected trust, the strategy also ensures the assets so transferred sit outside the individual's will, so it precludes the operation of various state family provisions and succession acts, which enable a wide range of family and non-family members to make a claim on a deceased estate. Importantly, the path to asset and estate planning success starts with a conversation with the client. So the first one is the letter. You can either call them up, have a seminar, or more importantly, just send this letter out. So again, there's no advice here, and all the protectors have been signed off by Abbott Mourly. If you'd like, when we go down and do the protector, if you don't feel comfortable about it, and most of you should because it's all been prepared, we're happy to sit down and do a 1 hour Zoom meeting with your client to go through the ins and outs of it. In that case, it will actually be signed off by Abbott Mourly. So it won't be signed off by you, it will be signed off by Abbott Mourly. So again, for our LightYear Docs users, normally the fee is $750, but for this one, it's $495. So let's go to the letter. Again, you put your logo, your details, all that sitting in there. Obviously, you've got your client's name as well. Protecting your family assets during life and after death. We're writing to all of our clients about the opportunity of protecting your assets from any litigation or government claim, plus a family provisions claim in the event of your departure. Litigation and family provisions claims are rife and may arise from someone falling in your home or investment property, or actually I've got to get rid of an, or investment property if you're a professional, investment property. If you're a professional indemnity claim, and definitely claim on your estate upon your death. Given Australia has the most lawyers per head of population in the world, it's not surprising. After all, they have to live somehow. Again, this is available, and I'd like you to, for those of you watching this, jump on Support Centre, and if you can fix up some of the grammar or you want to make a bit more feedback, please do so we can put it up. Again, this is a lifelong learning position at LightYear Docs. A real case in point, a family provision claim on your estate assets may result in long and costly court proceedings. In Western Australia in 2018, the judge of a WA Supreme Court castigated lawyers for taking 5 years and $500,000 legal fees to challenge a $600,000 estate consisting only of the deceased home. This is happening every day in Supreme Courts around Australia. We do not want that happen to you. So I'd actually take that Perth Now article and I would attach it to this letter. We're writing to let you know some exciting news that we've teamed up with lawyers and specialist asset protection estate planning advisor Abbott Mourly to provide the Protector and Asset Protection Trust Package. Not only provides asset protection, but assures your assets held for the benefit of those beneficiaries in your lineage or bloodline that you want. This will ensure your hard built assets are kept in the hands of your lineage. So the Protector involves the creation of a special purpose trust for the beneficiaries of your lineage or bloodline that you desire, including yourself and your spouse. If you have an existing trust, this may prove suitable unless it is potentially openly exposed because it runs a business or service. Once the asset protection trust is established, we transfer the equity in your current assets, including your family home, into the trust and then lend it back to you for your use. This means no tax or stamp duty issues, but more importantly, vital protection. As your advisor, we strongly recommend that together we undertake a simple three-step process to see whether the Protector's for you. 1, determine the value of all assets, net of liabilities that are in your name and thereby exposed. See the worksheet over to get you started, which I'll show you. Set up an appointment to go through the process for implementing the Protector. So this is where you guys come in. This is the call to action. How to ensure there are no tax consequences, who's to benefit from these assets during your life and also post your death for generations to come. So that's the bloodline or lineage discussion, or alternatively we can put it into a company. And then establish the chain of documentation, execute the relevant deeds and place them in our digital vault and provide copies for your safekeeping. The first 2 steps are complementary to our existing clients, normally $750. So what we're doing is we're saying, look, you do this, we'll do an assessment and have an appointment, there's no cost. Given the litigious society we live in and where state governments, the ATO and other federal agencies can garnish, take monies from your bank for unpaid debts. That actually happened to me. I had 2 speeding tickets from South Australia in a hire car. Can you believe it? They sent me the tickets to an old address and I didn't know about it. That somehow I was pinged with a $1,700, I just found on my bank account, a $1,700 deduction. I rang them up and it was actually from the state government of South Australia who garnished that amount directly from my bank account. I can tell you I was pretty pissed off, but anyway. And the danger of leaving your estate exposed to long and costly litigation from family provision claim, we feel that it's important for all our clients to examine the process to determine whether or not to protect their assets and legacy with the Protector. Now, again, this is a Word document, so change it as you see fit, particularly if you know the client. To get things started, we've attached a simple sheet where you can determine roughly the assets, their value, any money's owing them, the net value of the asset, and ultimately your total net equity is exposed and ready for protection. Once you've completed this, you can make an appointment with, and I mean, obviously, if you put your name down here, just say with myself, to look at your options, alternatively make the appointment, we can work through your net equity position. Let's work together now to take that weight off your shoulders. So again, just feel free. So data capture, determining your net equity. This is a simple process. So we can, if we want, as I said, it's just a Word doc. So let's drop that up into, determining your net equity. So what we could do is we could just make that change. We want to get a big emphasis on that there. So we will just have it centered and then we put that in there. Sorry. So data capture, determining your net equity. Okay, so we've got that. So again, you just change it as you see fit. This is a simple process. We don't want to blow their mind away. And the exact value of an asset as a family home does not need to be determined, just an approximate amount. All major assets should be included, such as family homes, investment property, shares, managed funds, unit trusts and other investments, cars, hardware, bikes, furniture, and other items of reasonable value. For example, my brother's got like a 10. So if I can put in there, Nigel's mountain bike value, can you believe this? $10,000, liability, zero, net value, $10,000. And then we can put our home at Manly Beach value, $2,500,000. So obviously you're going to get you just need rough values, that's all. So what will happen, I'll cover the ups and downs a bit later on, but what will happen is you'll get a good valuation and then you will effectively put in place this process here. You essentially want to pull out all the equity you can. So you just go through, the client will do that process. So it's nothing different from that. They'll bring this into you, and then you got your net equity. If that was the only one we've got there, then we've got like just over $2 million as our net equity, which is quite sizable. So what we want to do is we want to go through that process. They go through, and we want them to self-select. So hopefully the process should be send them the letter or send them this in an email form and just say it's really important. Take some of the copy out of here, put in the email, send it out to your clients, follow up with a letter directly to them, personal, private and confidential, and then follow up with a call as well to see if they want to make an appointment. The whole process is for you to go through and make the appointment, and then you show everything that happens up on the whiteboard. So let's just go to the protector. You're going to find it there. So there's two places. I can either go up here and I can put the protector, and this is just a bit like Google, so it should come up there. There's the protector. It's in strategy automation because it's got more than a couple of docs. Effectively, what we can do is there. Actually, Ashley, who's our COO, has basically said, if you'd like to, we can transfer the letter into an automated mailing platform. For example, if you've got MailChimp or one of the other ones there, Active Campaign, we can actually transfer it there so you can release it across all your clients, which would be brilliant because the whole idea is to just get it out there and let people self-select. And it's also not a bad position because you don't want to be, remember the dream that I had? You know, the client's coming to you later and they'll say, oh gosh, I've just done that. And you said, well, why? You could have put in place the protector. But it means you're getting the message out there now, work out your pricing and all that. Remember, our next webinar is going to be on the new will, pets, and also social media, pretty exciting. So what I'm going to do is I can go into there or I can go into my strategy automation, but I'm just going to pull that up there. Now, there's a lot of pricing here about the product. The protector is perfect for any business owner, professional person with assets in their name that may be subject to litigation for some small reason, may have their estate challenged under Family Provisions Act by children, grandchildren, former spouses, or family who believe they're entitled to a proportion of the estate if left out. Can it be digitally signed? Yeah, but you know, my preference is anything that might end up in the Supreme Court should be physically signed. That's the last thing you want to do is one side to say it's ultra vires or that it doesn't, you know, there's no standing because it's not executable. Then you're spending like $150,000 to work out whether digitally signing is okay. It doesn't make sense. Plus, you're charging premium. Now, here's the thing is, so it's a whole set of documents, and I'm going to take you through there. It takes probably 10 to 15 minutes. This video is on the support center. It's $450 is the cost, which I think is like cheap. As I said, if you have a look at most lawyers, you're paying, you know, anywhere from $3,500 to $20,000 for it. But if you're like in a, you know, like on one unlimited, you can do as many as you want. First thing I'd be doing for all of you unlimited, do it for yourself and all your partners. Absolutely crucial. The benefits, obviously, strategy automation. We'll look at that. You know, we'll actually be able to make some good money out of this. When you think about it, that it's crazy not to be on the unlimited package because surely there's one client in your database every month that you can pick up from this and charge maybe 6 or 7. You know, if you're charging $7,000 for, if I go back to this one here, definitely for a client here who's got a $2 million, a home that they want to protect, I'd absolutely, that's worth $7,000 or $8,000 easy. And that covers you for your license fee for the whole year. And you can do unlimited documents on it. Do you mean everything else is basically going to be profit? So let's go back. Frequently asked, what if my assets go down in value? Well, you don't do anything. So, because you're still secured for the same amount, it just means that the estate is actually going to be short or effectively could be bankrupt. So what if the assets go up in value? Then we're going to work out a process there. Ideally, if it goes up in value, then next year you'll do the same thing. So you work out your increase in equity. But what I'll do is I'll work out a process to make it really easily effective from that, bit like the DIP 7A process that we're putting in place for 30 June. So I'll go down and I'll just start the document. So I'm going to put it in grant test. So if I try to, just as a tip, if I try to start, nothing's happening there because this is already in one of my existing client folders. You need to just go, see where my cursor is. I backspace. That now gives me the green. And see how the green says grant test? If you don't get the green, you don't get the go ahead. So there, I've done the green and now start. So this is the process. So first off, I've got to give it a naming right because it's in grant test. So I'm going to put it in there. So this is going to be for the Smith test. I'll just go to Smith. Now, for those of you who are one of our LY strategist firms or licensees, you'll have your own logo code put in there. Here, because this is going to be an Abbott Mourly document from my firm, then it's going to be under Abbott Mourly. So I've got a common party there that's sitting effectively there, and which is perfect. And we have a look at all of that. So we go down and see. So the first thing is the common party. Now this is for me as an individual. Well, actually, what we'll do is we'll look at John Smith. So we've got actually we'll do Matthew Smith. Sorry. And then we go down, put his address, Smith Street, Sydney, New South Wales, 2000. And you'll see when we start to do these long forms of documents that it's absolutely crucial to put in these common parties, just makes it easy. So we're going to add another. So what we're doing is we're going to do a trust. So here I've got the Smith leading member trust. Now, a leading member trust essentially is just a discretionary trust that limits control to and beneficiaries to lineage or to bloodline. So what happens is you'll have your primary beneficiary being the leading member. So that in this instance, it'll be John Smith. So I've already set this up, presuming. And then the next leading, or Matthew Smith, and then the next leading member would be someone who's next in the lineage. So it's very easy, like you've got Prince Charles, Prince William, Prince George, so on and so forth. So we can put the next leading member who takes over appointorship and also trusteeship. They then become the primary beneficiary. Their spouse can be included as the primary beneficiary, but then all their lineage or their bloodline is now included as part of this process. So we've got a trustee is a company, and then we want to make sure that we've got the Smith leading member nominees, and that's a special. The difference between that is that on death, all the shares are held by the leading member appointor, but when they die, the leading member appointor, then the last thing we want is we've done all this stuff, and then the shares of the trustee company find their way into the estate. It doesn't make sense. So what happens, those shares are cancelled and the next leading member appointor gets a brand new shares, which is perfect. So we'll go through the ACE again, 1, 2, 3. So we'll do the same on Smith Street, Sydney, New South Wales, 2000. How many directors does the company have? Let's just say we've got one director, and that is Matthew Smith. Okay, so we go down to the next one. Okay, so now if you haven't got, I'm assuming I've already got a leading member discretionary trust. Any point in time, it's not a bad idea to save answers as we go through the process. Just, and that means that when we come up here, we'll see my in progress docs if I save answers, document preview, and also your answer survey. So would you like to establish a trust? If I go yes, yes, then what will happen there is that will set up a leading member discretionary trust. So this is a special purpose trust that we've got. Now I'm assuming I've already got one here. Now there's no cost. I mean, if you say no, then the pricing is $450, and if you're unlimited, it doesn't make any difference, it's the same. So it doesn't hurt for us to set up special purpose ones If you want to set up a company, then again, it's going to be that leading member nominee company, discretionary trust nominee company, which essentially what will happen there is, again, the shares will be issued to Matthew, but Matthew dies, and let's say then it's his son, Ben, that takes over. Provided Ben's 18 or more, then effectively what will happen there, he now takes over and Matthew's shares are effectively cancelled. But if you set up the company, again, there's no cost. So it's all one built-in suite of documents, but obviously you're going to have to pay an ASIC fee. So that's why I'm not going through the process at the moment. So you'd have to pay an ASIC fee. So whatever the registration is, there's no loading on that. So these are the documents. First off, you need a solvency certificate from your accountant, and that'll become apparent to basically say solvent. So there's a deed of gift. Now, if you have shares and cash and equity, so if I've got equity in a family home, the problem is I can't transfer that portion of the family home into the trust. I could potentially, the only problem is that the bank is probably going to get, can you imagine the drama would happen with the bank there? So I can transfer that equity in, and obviously there's no stamp duty or capital gains tax consequences. You will see we need to put in place a mortgage deed, and so you need to go and talk to the bank and just say simply this is what's happening, and then we need to get a second mortgage. Now that's not going to change the rights that they have anyway in their first mortgage. Now, if we've got shares, we transfer them in. There's obviously no, generally if it's listed shares, there's no stamp duty. There might be capital gains tax. So we can transfer, if we want, directly shares that in capital losses. So we're realising capital losses, we can transfer them in directly. If not, we can just simply transfer the equity in. So to transfer the equity in, we're going to have to use a promissory note. So we work out the equity in all our investments. Remember, that goes back to this sheet. But obviously, you guys are going to have a bit more formal, an Excel spreadsheet that actually gives this. And you want to keep that updated on a regular basis. So you've got that of all their assets that are basically sitting in here. Remember, this can be also not only over individual as this one is, it can also be over a discretionary trust. So the promissory note we work out, then there's a loan agreement back. So what will happen is we've got the promissory note and then there's a loan agreement. There's a mortgage deed, and you can also do a personal guarantee if you want. Again, that just makes it really up and up. So it's really bona fide. So they're all the documents. As I said before, I can establish the trust, but I've decided not to in this instance because I already know the trust. Because remember, I've done this Smith leading member trust. So let's go down. The first one you can see here is the accountant. Now, the benefit about it is I could have put the accountant's name in there as a common party, but what I'm going to do now is I can just put the firm's name in there, or I can put in there John House, BNB Accountants, and then we can put there 5 John Street, Sydney, New South Wales, 2000. And again, this is, I'm actually showing you what it looks like live. So we go to the next one. And again, I could have done it through this. So who is the person giving the gift? So that's, in this instance, it's going to be Matthew. So I just put Matthew's name in there. Bingo. So Matthew's there. So again, it could have come from a company or a trust. The only thing about company and gifts, you just watch out for Div 7A, and also likely with a trust with Div 7A. So we can actually get rid of UPEs as well if we want to. SMSF, not really a gift, but we've just put that in there, those as well. So we put those, and Ash just said 5 people on the webinar have already signed up purchasing these. So good on you. It's crazy. Not all of us need to do that. So the next one is the giftee. So here I'm doing it into that trust. So again, I could have set up the special purpose in this package, but I know it's the Smith leading member trust. See how it just comes in. So that's the beautiful thing about what we call robotic processing automation. So the gift here, let's just say it's all going to happen tomorrow. Where's the deed executed? Let's go to just New South Wales. I can do cash. So I've worked out, I go back to my sheet, and this is all AAK, remember? So it's actually the cash that I'm doing, and cash in this instance means the promissory note. It's going to be, and here I write $2,010,000. Now, alternatively, we could say that there's shares. Remember, if there's shares with the capital gain, we put them in the gift. If there's shares with losses, I'm not having any gain, I could put 1,000, here's a good one, Telstra shares, because they've never made a gain. So I can switch those in directly if I want. I can transfer in if I've got UPEs, might as well transfer those in, and other. So you can basically put in, whatever stuff you've got in there. So you've got to work out an amount of gift. And remember, at any point in time, if you're going through these documents, you've got a question, just contact us at support, and then we'll come back to you pretty quickly. But again, make sure you look at this again. Okay, so we haven't got the cashola, so we need a promissory note. So the promisor is the person who's doing the gift. So again, it's pretty easy. It's Matthew. The promisee is going to be our trust, which is the Smith Leading Member Trust. So you can see how easy. Details of execution. Again, we're going to do, everything's happening tomorrow. The client's really hot to trot. New South Wales and promissory note. It's intended to show promissory note only. Well, not necessarily that. So is the promissory trustee of SMSF? No. Termination date. So that needs, in fact, just leave that with me. I will be changing that, but essentially I would go, because we're promissorying that equity in. So rather than doing short dated, I would be doing a long dated one. So let's say it's 15 years. So I just need to change that. So sorry about that one. So rather than 15 years, I'll put in there the 12th of the 2nd, 2035. So that's a termination date on the promissory note. So I will fix that up straight after this meeting. Sorry about that. Okay, so how much is a promissory note? It's 2010000. Will the promisor also be required to promise the compensation payment on the termination date? So that's, for example, I just go, no. Will there be a late payment charge? No. So the compensation payment is just like an interest payment, so no late payment charges. Okay, so we go to the lender. So the lender is not the individual, because the money is now, the equity is now gone into the trust, and we need the equity back. So there's going to be the trustee of the trust. And the borrower is going to be the individual, who is Matthew Smith. And then we go down to the agreement details, and this is important. So this is where it all starts. So the date agreement is going to start tomorrow. Date of commencement of the loan starts tomorrow. State with a loan agreement, New South Wales. Is the loan fixed or variable? We'll go fixed. Principal loan amount, 2010000. Is that right? Yeah. 15 years. So just write that in. What's the commencement interest rate? So I'll use the current Reserve Bank rate, 1.9%. Interest payable annually in arrears, or you can simply pay at the end. So I've got if it's 1.9% on 2 million, so therefore it's going. Let's just say that it's going to be $4,200 per annum. So that's interest payable in arrears. So I need to actually work that amount out. Now, personal guarantee, absolutely. So it starts from tomorrow. Is the guarantor the same as the borrower? Yes. Mortgage deed, absolutely. 12th, real estate is, and then we'd put our folio number, but just let's say it's 5 Esplanade, Manly. I don't know what the postcode is, so 205, what to say. Okay, so that's a mortgage there, and obviously I'd have to register the mortgage. If it's just personal assets, then we can register under PPSL, which we're working on as well to get that integrated, but that'll be down the track. So what happens is, you can see that only took like 10 minutes. The big one is to get that common parties that are really important. and more common parties in the net equity we're pretty right, and obviously want to get that leading member trust right. So here's our protector. It all comes up in the Abbott Mourly because that's our logo. Alternatively, it could come up in your logo if you're a licensee, etc. So I've got a solvency certificate, deed of gift, promissory note, loan agreement, mortgage deed, personal guarantee. So that's the contents of this package. Now, obviously, if we had companies and trusts, they would also be in there as well. So the accountant statements of financial solvency, I, John Backhouse, the B&B, blah, 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 state that having reviewed and considered the financial position of Matthew Smith immediately before making the gift recorded by the deed of gift, executed with giftees and gifter, I've reasonable grounds to believe that Matthew Smith, and it should be, is able to pay their debts as and when they fall due. So we go through that. In making a decision, I have discussed the financial position with the giftees and also have prepared and reviewed their financial statements. So I've got the deed of gift basically sitting here and the trust. I won't go through all of that. As I said, this is the beautiful thing about strategy automation. So we've got Matthew and the giftee. We've got all the gift here. We should have down here the transfer of the gift, what happens. It's quite an extensive gift because we actually use this for our just a normal deed of gift. So it's a proper deed of gift. The gifted property is cash and Telstra shares. We then have our deed of promissory note that comes in for that one. So the promisor is Matthew Smith, promisee. We've got the deed. So financial year, compensation payment, there's no compensation payment. Termination date, February the 12th, 2035. The sum is 2 million payable. Actually, that would have to change. So sorry, that was my mistake because I'd have to value those Telstra shares. But if I wanted to do that, all I have to do is just go back in here. I go back in and go, oh my God, I made a mistake. I haven't put that in. I go back into my vaults. Can you see I've done that? I go into grant test and up there is the protector. I would go in, I would relaunch. And then effectively what I would do is I then work out I'd go into, for example, the promisor, promisees, okay, details of execution. So if I go in the promise details, let's say the Telstra shares were worth 40,000, then that jumps up to 40,000. Does that make sense? So what I do is that's how easy the things are to change. But anyway, let's go back here. No late payment charges will apply. Governing laws, New South Wales, executors of deed, blah, 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 blah. Now there's a loan agreement between the lender and the borrower. Same stuff as we had a look before. And, you know, I can go through all of this. You've got your schedules. It's like a real bona fide loan agreement. So you have to have it up and up. Otherwise, it's going to get knocked out in court. So again, we've got the borrower is Matthew Smith. Get everything witness. Again, that's a preference because imagine if you had a digital signature and say there's no witnessing, the first thing anyone's going to do, anyone who's trying to challenge it, any lawyer would say, hold on, digital signatures don't apply here. So you want to get signatures from everyone. Again, that would have had to change if I'm doing shares, 15-year payable, 1.9% per annum. It's fixed, which isn't a bad thing. Maybe you can do 1% fixed. Then we've got the guarantor, which is important. So that's the personal guarantee there as well. So you just want to make sure that, you know, you're trying to clean out absolutely everything from Matthew. So he's given away, you know, everything, so that if it's challenged, he has absolutely nothing. And then the mortgage deed is going to be over the property in Manly. And you can see down here 5 Esplanade. So you're going to go and register that mortgage, which isn't a difficult process. So that's it. That's the protector. So you can see really when we get down to the use, this is a case study, I won't worry about that. But when we get down to using the protector, there's really not many people who can't be used for. So from Sean Costello, does interest need to be paid? Well, generally, I think from interest is that there needs to be some compensation because for a contract to be valid at law, there has to be some consideration. So unless there was something else, I would at least have some form of interest. Can you use an individual trustee? Absolutely. So can you use an isolation without a full estate plan? Sean, that's a really good question, because if I've done this right, what is left in the estate? There'll be zero. So I'd still go through the process of doing wills and come along to my session next week. But really, our whole idea is to keep things away from the Family Provisions Act. I'll go through the situation next week for family provisions and the notional estate in New South Wales, but that doesn't apply elsewhere. Can you assist in PPSR registration? Not at this stage, but Ashley is looking at that. So we will be doing that. But it's very easy to go on, and I did it yesterday myself, registered myself under PPSR. So it's a pretty easy process to effectively do. But effectively, we'll have that all integrated. So while I'm building all these documents and strategy automation, Ash is starting to build a lot of the integrations that you'll see with class and BGL and stuff like that. So as I said, if you guys are licensees or you're on our unlimited package, which is only $7.95 or $5.95, if you're not taking CBD or tech support from me, just do it for yourself straight away. All you got to do is work out your net equity around abouts, and then flip that using this package. Again, I'd set up a special purpose leading member trust for this if it's quite sizable amounts. Remember, this can grow over a period of time. Same way with this is we can also use this for other family members. So, for example, a spouse can put hers into the same trust. And then we can also have a family trust which might be running a business. We can put in their net equity in here as well, because the last thing you want is cash, receivables, stuff like that stuck in a business if the business goes broke or is sued, so on and so forth. Now, if you need legal sign-off, just contact Tony Tanner-Willis at Abbott Mourly if you need that final sign-off. Again, if you've got any client scenarios or you're working through, through the process, just flip us. Remember that support. The good thing about the support, if you flick an email to us, the danger about that is that it gets lost. With the support, it can't get lost because it goes to all of our support team. And our support team, Michael Jeffries is like a 25-year company veteran. You've got Ashley, who's been around for a long time, and myself. So all your support is actually be done at a high level. With the 2-day conference, we're actually looking at 5 days. It's going to be succession, asset protection, estate planning. Now, SMSFs are really crucial, and I'll be going through a lot of stuff there, but SMSFs are no longer the be-all and end-all. This is where the action is starting to happen. And those people who are attending will actually come out with an accreditation as a succession and asset protection specialist, and that's the first. So from our perspective, just as I sign off, Ash just said we've got about 3 more people we can fit onto that conference. Certainly it's worthwhile. It's still only $595 if you want to go down that track, if she stands up, so that'll be fine. For us, this is a value-added strategy. As I said, the minimum price you'd be able to get this from any legal firm is at least $3,500, and it's going to take you weeks. You saw how easy it is to do. They don't have automation, so it takes them a long time to do it. The main thing is to get that equity, and more importantly, get the clients in. If you want Ash to get involved there, so just Ash at ilovesmsf.com or Ash at lightyeardocs.com.au. She'll build you a template, and she's got it shown up there. So if you have a look at the panelists there, if you can see on the chat line, she can build you a template and show you on there for MailChimp for Active Campaign, which you can send out to your clients. Again, it's better to warn them, get them out there, get an appointment, come in, show them the benefits of what can happen. Remember, it's not sold just on asset protection during life, it's also asset protection post-death as well. So our thing is not about docs. I mean, docs are really old-fashioned. I mean, we've got the cheapest docs around at $99, so please use that. It's where you can start to build these strategies and real value-added strategies that really will make money for you guys. And I know that if we're delivering good strategies that are useful for your clients, and really what clients shouldn't be fitting in there, then the client's going to win, because one is you can, if the client wants to build a brand new trust, it's not going to cost, or it shouldn't cost them anything. If they do a company, then they just pay the ASIC fee. So your fee can be the same fee with or without a trust, or you can add, look, I don't care. It's the way you split it up. It's up to you. But our strategies are designed there to make money for you, and we'll be going through a whole branch of them on those 2 days if you've got some opportunity to come. So anyway, it's enough from me. What I'll do is we'll be going through this. So this is a soft launch. So next week's our hard launch to our big database. So that'll be next Tuesday, I think. Thursday, make sure you come along for the wheels. So you're actually going to see pets, social media, and now built-in optional testamentary trusts or mandatory testamentary trust. So I've been working a lot on this, so that will be released next week. Again, these are things for you guys to make money from. So we're building awesome legal services within your business without having to pay for lawyers. Anyway, it's Grant Abbott signing off, and looking forward to seeing you very shortly. This will be up very shortly. It's Grant Abbott signing off.